Immigration attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Yes, also here on Memorial Day. So go ahead, put your questions in the comments. This is going to be a quick live because even though it is a holiday, we have opened up today to fit in consultations because so many individuals are needing help. So I have to jump straight into appointments for the rest of the day. But I do want to still answer some of your questions that we could get to in the next 5 minutes, and also to talk to you about that topic I promised to talk to you about, which is the I-601A waiver. Now, Friday we talked about getting your green card through a parent, but there are also some limitations to that. If you're here, you're 21 or over and you've already overstayed, or you're the spouse of a permanent resident or child of a permanent resident and you've already overstayed, you you will likely not be able to qualify for adjustment of status. That's getting the green card while here, unless you're applying for VAWA. And so in a case like that, what's the answer, right? If you're already here, you've overstayed, you're stuck here, you can't leave to get the green card, but you can't stay to get the green card. What's the solution? Well, the solution here is going to be the I-601A waiver. And the I-601A waiver allows you to, at the time they're ready to process your application, if you're here in the US, it allows you to apply for forgiveness for the overstay and unlawful presence based on the extreme hardship of your permanent resident or citizen, spouse, or parent. So people who have a spouse or parent who is a citizen or resident can qualify for this special waiver. You do have to show that your spouse or parent will experience extreme hardship if you don't get the green card. And extreme hardship doesn't mean that your parents are going to miss you. They're going to, there has to be more than that. Extreme hardship usually means that the consequences on your spouse or your parent will be more severe than the normal. They will experience severe consequences if you can't get the green card. That may be economic, that may be in relations to health, or financial type of hardships that may result as a result of not being able to be together as as a family, either with your parent or with your spouse. And so it does take a lot of hard work to get to the point where you can get the I-601 waiver approved. Now keep in mind that first, your petition has to be approved. Your family petition or employment-based petition has to be approved, and then once approved, your priority date, that's when it's time to apply for the waiver. When you apply for the waiver doesn't allow you to stay here in the US. So that's another thing you have to consider here. It allows you to get forgiveness for the overstay so that when you leave the country to go to your interview, you're not going to face that 10-year bar. So that's the purpose of it, is to waive the 10-year bar if you left the country to go to the interview. Now, an essential point of this is you cannot have any other immigration violations other than the unlawful presence and overstay. If you do, you will not qualify for this. And if you leave the country with, say, you have fraud or misrepresentation or other type or arrest, and you get approved for this waiver because maybe they didn't pick up on that, you go to the interview at the embassy, they can turn around and say, oh, we forgave you for the overstay, but you have other issues going on that you have not been forgiven for, and because of that, you're stuck. So in order to avoid being stuck, it's essential to make sure you don't have any other underlying inadmissibilities or problems with your application. Now, the I-601A waiver allows you to stay here and wait for it to be approved. If it's not approved, then it means you are not supposed to go to the embassy to your final interview. If it's approved and all is well with your background, then sure, at that point, it is a safe bet to go to the interview at the embassy. The I-601 waiver does not allow you to get a work permit while you're waiting for this entire process to move forward. So that's also another disadvantage with this process, is that you're still waiting here for a process to go forward, but you are not going to get a work permit. But it allows you to get unstuck. So that's the benefit here, is you're when you're in a position where you have to apply for the I-601A waiver, you can't leave to go get the green card and you can't stay to get the green card. Well, this allows you to leave to go get your green card. All right, so I'm going to answer one or two questions quickly, and then I have to head out. Um, for those of you who are here, I'm wishing you a good day. And hopefully you can get your day off too. I have a burning issue. I really hope you can help. I'm in the States on H-2B visa, and the employer doesn't want to reimburse our visa fee and plane fare, and we have to be deployed or told where. So give us a call. There may be issues here and they may lead to immigration relief, but I need to find out what's going on here. Why don't they want to reimburse the fees? And what are the other issues going on here? So we'll have to talk about that in a consultation. Go ahead, schedule. The calendar is filling up right now. We are going into consultations in end of June and July. So go ahead, if you want to go ahead and get help for your particular matter and you want to do it ASAP, schedule your consultation now, because right now we are going into end of June and July for consultations. Hi there, it's nice to see you on YouTube. Would a loss of job on my part, not the green card holder, be considered? I'm not sure. I didn't see the other part of your question. So Mindy, I don't see the other part of your question here about. Now, keep in mind, if you're dealing with an affidavit of support, the lost job is going to be considered for the petitioner and not for the immigrant. Now, while I just wait for one or two more questions to come in, because I do have to run out, let me explain to you how to get in touch so you can schedule your appointment. You can do it by yourself without speaking to a staff member by going to the link in the profile and clicking that button that says schedule your own appointment. However, if you would like to speak to a staff member first to be able to get some assistance with scheduling, call the number. It's at the bottom of the screen, and it's also on the website and also all over my videos and in the text of videos. So go ahead and do that. So I see one here. Can an employer help you get status if you're out of status? So it is. If an employer is promising you that, be very wary. The I-601A waiver can be a way that an employer can help you if you have a U.S. citizen or legal permanent resident spouse or parent. However, if you can't apply for a waiver and you're already out of status, it's highly unlikely the employer is going to be able to help you. If they're promising you that, or if you found yourself in a job position because they promise you that, you may have a case of trafficking going on, and this is where you should call and let's evaluate all your facts here. How does USCIS calculate the months after applying fingerprints to your I-765? Is it from the day they receive the application? So it's from the day they receive the application. All right, I have to head out. I'm going to be back, and I'll be back much earlier so we can get more questions in and I can give you more information. So just go ahead and look out for me tomorrow around lunchtime and we can talk more. So if I didn't get to your questions, go ahead and ask those questions tomorrow. Otherwise, go ahead, call, schedule your consultation so we can help you as soon as possible and get started on your work permit, your green card application. All right, have a good one. See you tomorrow. Bye-bye.